The essence of the Indian judiciary is to provide a space for democratic dialogue, for reasoned dialogue, where logic prevails over the passions of the moment. Let me begin my lecture with the plot of Herman Melville's Billy Budd. The story follows Billy, who is a sailor who has an occasional issue of stuttering when he speaks. When accused of a mutiny on board and called to justify the accusation, Billy is unable to speak because of his vocal disability. Out of rage for his inability to express himself, he strikes at the accuser, killing him on board. A tribunal is then assembled to decide upon Billy's guilt. Melville describes that the Mutiny Act under which Billy was charged does not provide any exceptions for unintentional and gravely provoked actions because of the risk of mutiny is greater. The judge adopts a formalistic interpretation of the law, convicting Billy. The story of Billy Budd offers two thought-provoking insights and questions. First, is the purpose of the law to provide unjust outcomes? And second, what should be the approach which should be adopted by judges in adjudicating upon real-time cases? This evening, I wish to address the two questions which I have formulated by drawing from my own experiences of adjudication, which spans over 24 years as a judge. Let me begin by identifying the purpose of the law. The simple answer to the question is that the law brings orderliness and certainty in our society and our polity. In other words, the law humanizes people. For example, laws convicting persons for murder or war crimes or genocide are clearly to protect humanity because they provide an institutional framework to combat the dehumanizing effects of human transactions. But as you engage with the law, you would also uncover the potential of the law to dehumanize individuals or a category of individuals. I administer the law as a judge of a contemporary Supreme Court in independent India. But I'm deeply conscious of the fact that the same law which can be an instrument of justice was a form of colonial oppression in the years before independence. So the way the law is administered depends and defines the course of justice. This is primarily because the state may adopt a purpose-oriented approach while enacting laws which may have a consequential impact on constitutional values such as justice, equality, liberty, dignity, and individual autonomy. The purpose-oriented approach of the state, the modern state, is predominantly reflected in provisions which deprioritize the rights of individuals to achieve a larger collective good, particularly in legislation dealing with areas such as economic development or national security. In addition, the state which is vested with the power to protect and enforce the rights of persons may adopt a paternalistic approach by viewing citizens as its subjects, as not as persons. The second way in which the law dehumanizes is by not granting institutional recognition or by granting partial institutional recognition to personhood. As Hannah Arendt argues, a human outside of institutions cannot be fully human. She argues that institutional recognition, similar to a stage mask, enables one to appear equal to others. However, once stripped of this mask of institutional recognition, there is a rightless human being with a diminished role in the public sphere. I would go a step further to argue that the lack of institutional recognition not only impacts the role of the individual in the public sphere, but also their roles in the private sphere as well. This is because the lack of public recognition diminishes personhood, which is reflected in the way a person would conduct themselves. This approach to dehumanization is usually adopted by states in legislations which entrench the social discrimination faced by groups. The denial to recognize the right to vote of women in history is an example. The dehumanization of women due to partial institutional recognition subjugated women not merely in the private sphere, but also in the public sphere. Another example can be found in Section 10 of Madras Regulation 11 of 1816, which provided two kinds of punishments based on the caste of the offender, thereby dehumanizing members belonging to the marginalized castes. According to the provision, the general penalty was to lock up an offender in a makeshift jail in the village for a maximum of 12 hours. However, the offender was to be put in stocks for up to 6 hours if the offender belonged to, quote unquote, any of the lower castes. The punishment by stocks was only abolished 103 years later by the Madras Village Courts Act. The third way in which the law may dehumanize the beneficiaries is by the use of humiliating statutory language. Dehumanizing language contributes to dehumanizing behavior. A group is more likely to be subject to dehumanizing behavior if they are described in a dehumanizing manner, particularly in a formal legal rule. For example, Article 335 of the Constitution of India states that the claims of the members of the scheduled castes and the scheduled tribes must be taken into consideration consistently with the maintenance of the efficiency of administration. The Constitution does not define what is meant by efficiency, but judgments of the Supreme Court in the early 1960s and 70s had interpreted this provision to mean merit and observed that reservation or affirmative action leads to a dilution of efficiency or merit. This interpretation leads to the dehumanizing inference that students who have secured seats through affirmative action are less competent. In two of my recent judgments, I read the phrase efficiency as an elucidation of the principle of equal opportunity, arguing that there is greater efficiency in our services if there is an equal representation to members belonging to marginalized communities. So if we define merit in terms of inclusion and not in terms of exclusion, that there is an intrinsic virtue in bringing those who have been from the marginalized segments of our societies into the mainstream by giving them an equal opportunity to succeed in a social transformation. Now, the easiest way to rectify dehumanizing by the law is obviously to rehumanize the law itself. The law can rehumanize by expunging the use of humiliating statutory language, by granting institutional recognition to persons, and by balancing the rights of individuals with the weighty purposes of the state. But in a practical world, this does not translate into reality for numerous reasons. The laws are improved through incremental steps. The state may be unwilling to balance rights against weighty purposes, and the legislature may assume that colloquial terms, when used in a statute, are more widely understood by the people. This is where the courts step in. I believe that the laws can be humanized when a judge adopts a nuanced and humanizing approach towards adjudication. There are 5 core components to the humanizing model of adjudication in our contemporary courts. The first is the humanizing through the function of judicial review. In this component, the court, while interpreting the constitutional validity of laws, shifts away from a purpose-oriented approach to an effects-oriented approach. In other words, the judge does not just rest content with inquiring what is the purpose of the law, but focuses instead on the effect of the law. By shifting to an effects-oriented approach, courts analyze if the law is violative of constitutional values and has a dehumanizing effect. For example, in our judgment in a case which is known as Anuj Garg, the Supreme Court of India struck down a provision which barred the employment of women in the establishments where liquor was sold for public consumption, observing that the provision ends up victimizing its subject in the name of protection. The humanized approach is also evident in the expansive reading of socio-economic rights. For example, the Supreme Court in Olga Tellis recognized the right to livelihood of citizens who were slum dwellers. Recently, in M.K. Ranjit Singh, where we laid down the fundamental principle of an enforceable right to climate change or the protection against climate change, The bench of which I was a part recognized the right against the adverse effects of climate change which are affecting our marginalized communities, the most vulnerable in our societies. These judgments, like the numerous others which provide an expansive reading of socio-economic rights, recognize the citizens not as subjects, but as persons who require certain basic conditions to live a life of dignity. The second component of the humanizing approach emphasizes procedural justice. The critical dimensions of procedural fairness, such as the right to be heard fairly and to be treated with dignity, neutrality, and by attaining a sense of legitimacy in the decision-making process and by the decision-making authority, humanizes the process of adjudication. In April last year, the Supreme Court, in a judgment in a Media One case, made significant strides on this component. In this case, the bench of which I was a part, and I was presiding over the bench, had to decide if the disclosure of material in a sealed cover to the court to the exclusion of the litigating party was valid. What is essentially done in this process is that the material is removed from the opposite party's docket, but continues to remain on the docket of the court. The Indian Supreme Court, in its judgment, for the first time applied a heightened standard of proportionality to review the infringement of procedural rights. The third component of this approach is the necessity to understand the unique lived experiences of the parties. What if the victim of rape is not just a woman, but a minor, a young girl? What happens if the minor girl who has been raped is not just a woman and a minor, but a differently abled minor? What happens if she's a woman, a minor, a differently abled person who also belongs to marginalized groups? The law is general and rigid. The core of the art of adjudication lies in the ability to understand and sympathize with the lived experiences of the parties. In the example which I just gave you, the court has to have a robust understanding of what we in law call intersectional discrimination. This is the human factor underlying adjudication. The court's consideration of the mitigating and aggravating conditions in its sentencing policy is an apt instance of the human element in adjudication. The court's understanding of the mitigating factors must not be formalistic and a mechanical exercise. I recall that in one of the cases before me, a student belonging to a marginalized community was unable to secure admission to the prestigious Indian Institute of Technology in Bombay due to the non-payment of fees because of a server error. The student had no resources of himself. His sister had provided her credit card to him, but there was an error in the server and he couldn't pay his fees on time. The Supreme Court, in the exercise of the power to do complete justice, directed that a seat be earmarked for the candidate, since it would be a travesty of justice otherwise. In my opinion, it was the court's bounden duty to ensure that a young candidate, particularly one belonging to a marginalized community, which faced severe socioeconomic backwardness, was not denied of admission for the non-payment of fees as reflected on the server at the relevant time that evening. The fourth component of the approach is humanizing the language which is used in judgments. It is necessary for courts to shed the dehumanizing language and adopt inclusive and humane language in our judgments. For example, the writ of habeas corpus translates to the remedy of producing the body. However, the court, while writing a judgment disposing of a writ of habeas corpus, must humanize the detinue. Behind the body is a human face, a soul, a mind, a living being, an entity. The language of the judgment must reveal that the court is dealing with a person of a specific personality and a certain background, and not just a body or a corpus, as traditional legal notions would call it. The courts must also not use prejudicial and stereotypical language in judgments while referring to members of certain groups, particularly those belonging to marginalized communities, or use gender-insensitive language. The use of prejudicial language promotes a grim perception of marginalized communities. For example, judgments must not refer to a member of a backward class as a lower caste. The appropriate term is marginalized caste. The fifth and final component is the humanization of the justice delivery mechanism itself. The justice delivery system, like the law, also has the potential to dehumanize. The long queues for the filing of cases, the hassle of checking status of filings leaves parties dehumanized by the end of it. As the Chief Justice of India, I have incorporated the use of technology in the administrative functions of the courts. This enables the litigants to complete the procedural requirements from the comfort of their homes or internet service centers. This also prevents the incessant interaction of the parties with the administrative staff, who, after a long day at work and upon answering innumerable questions, may find themselves but in a moment of despair. Thus, technological intervention has humanized the process for the parties and the administrative staff of our courts. It is my duty to, however, place a small caveat. I am not a proponent of the complete automation of procedures, since I believe that the absence of the human mind will remove the human element from the process. It is important that we understand and value the pros and the cons of technological usage to ensure a humanized mechanism of justice. Artificial intelligence is replete with unique possibilities for the future. We must also ensure that we impose guardrails, as a very distinguished academic has called it, guardrails which would control artificial intelligence itself and not shift the process of adjudication from a judge to a robot. I therefore end my opening remarks with these thoughts. I hope I have been able to share some of my own experiences of judging over the last 24 years, and I look forward to having your questions, which I can then perhaps try and address to the best of my ability. Thank you.